Hi, welcome to Legally Speaking. I'm your host, Sophia Haynes. Legally Speaking is a public service of You and the Law, whose mission is to provide resources and information to empower you in your legal affairs. While we provide legal information, this is not construed as legal advice, so if the services of a licensed attorney, we advise you to do so. Today, we're talking about employment discrimination. Our guest is Ms. Yasmin.
That's right.
Yanthis-Bailey. Yasmin is a labor and employment attorney who's been practicing for approximately 10 years. She's worked in both defense counsel and in the federal service. She enjoys litigating and discussing employment-related matters to find impactful solutions to complex problems, and she loves analyzing organizational industrial psychology issues. We welcome Yasmin to our show today.
Thank you.
Now, Yasmin, employment discrimination is something that's been around for a very long time, and I think there may be some myths out there exactly as to what employment discrimination is, and there may be some people who not know exactly if they have an employment discrimination issue. So if we can start out the show to talk about exactly what is employment discrimination.
Okay, thank you. No, I think that's a great question, and I think it is such a broad subject that sometimes people don't know. They may be on their jobs working and feel that something is off, feel as though an unfair decision or situation has occurred, and they're not certain if this is discrimination that's covered under different federal laws or state laws or sort of protected activity, or if it is a situation where it's more hurt feelings, that sort of thing, that someone may have said something that wasn't discriminatory but wasn't behavior that's acceptable in the workplace. So sort of differentiating between, was this a situation where someone hurt my feelings, said something off the cuff that was inappropriate in the workplace and is not actionable for whatever circumstances, or is this an occurrence that perhaps has some sort of pattern, perhaps is so evasive and just pointed that it is actionable, that certain things become so, if you will, upsetting in an environment or just reach a certain level that courts deem this to be activity that's sometimes found to be discrimination, etc., where you can bring a claim and have an action to proceed based on certain things that may have occurred. So while it's a very broad subject, I do think that there is a line that kind of defines discrimination in the workplace versus just poor decision-making, bad behavior.
By management.
By management, by coworkers.
So it can involve in management as well as coworkers.
It sometimes can, because you don't really just have to have a supervisor that is doing discriminatory activity to necessarily be able to bring an employment claim. There's a whole sort of cat's paw theory where it may not be your supervisor who's making certain discriminatory decisions, but it may be someone who has your supervisor's ear, that sort of thing.
So there can be influence as well as power.
Exactly.
Now, when we talk about discrimination, we think a lot of times about race.
Right.
So are there what is the governing law for it? Because we hear a lot about Title VII. Is that the background on discrimination type claims?
Sure, and that's a vast majority of what I've practiced, although there are certainly protections within state laws and even different counties. For example, here in Atlanta, there is law within the city that covers discriminatory activity far broader than Title VII.
Okay.
And various states or municipalities, cities may make those sort of decisions, but you're right, like Title VII is generally the background or the statute that you're going to deal with when you're talking about discrimination based on race, discrimination based on gender, discrimination based on religion, discrimination based on...
That was my next question. What are the other types of employment discrimination? I think we do hear about age, we do hear about religion, we definitely hear about race. So what are some other areas that people may be on the lookout for they could be discriminated against?
Disability, that's one that is certainly rising, especially as you have a workforce and people that are working, a continuum of years, not necessarily retiring at a certain point. And so you can be discriminated against based on your disability if the employer is not sort of receptive to any accommodation requests that you make. You can also be discriminated against in retaliation for having sort of participated in protected activity.
Well, let's talk about that, because though you use a lot of terms, protected activity and cat's paw, and we want to make sure that
Right.
our audience understands, in common terms, what all that means. So let's just talk about, we'll just pick one out, the disability.
Okay.
So how would I know if I am being discriminated against because of a disability that I may have?
Sure. Sometimes you can see in a work environment, maybe the person, you're able to do all of your work assignments, all of your job duties and functions, but you may need an accommodation, whether it's because you have limited movement and so you need some sort of equipment to help you type things, or to have some sort of accommodation that could help you better accomplish whatever your work goals are. Employers do have an obligation, and of course this is all subject to fitting within being subject to the ADA, which has different thresholds for the number of employees that you need to have.
So what's ADA?
That is the act that covers
American with Disabilities Act?
Yes,
okay, we heard
that
about
covers disability and protects employees from being in a situation where they're able to do all the work but just need an accommodation, need some sort of support from the employer, or change in their work responsibilities. Not necessarily a change in what they're supposed to do, but a change in perhaps the way that they do things. And employers are required to evaluate, analyze, and see if an accommodation can be provided, if this person has a disability that substantially affects or impairs their life, that sort of thing. So
the law requires them to make that accommodation for them.
Well, it's not as easy as, of course, the law requires it. You can't say, well, I need to be in sunlight all day, so you better give me an office with a window, or I need to have fresh air on me all the time, so you better have my circulation coming in here more. So you can't necessarily make demands. It really is an interactive process, where employees need to be talking with their managers, talking with their supervisors, and really starting to engage in finding out ways that the employer can accommodate.
And that's what, if I'm otherwise qualified, right?
Oh yeah, exactly. You can't just not be able to do the work, or be in a position where you can't complete your job assignments or tasks, and expect the employer to put all of these things in place that would make it so that you could accomplish that work. But they do have a responsibility to take a reasonable approach and really work with employees to try to find an accommodation that would fit both. And I mean, oftentimes employers are sort of hesitant at first to kind of really delve into accommodation. Depends on the employer, of course, that sort of thing. But you will see that many employers will eventually start to work with folks to find something that can fit, because once they know that they're expected to do this is something that the law requires of them, that interactive process can oftentimes produce results that will work well for the employer and for the employee. And if it doesn't, of course, that's when we get to litigation. And
so let's switch over to, how would I know if I'm being discriminated against maybe race or age?
Right. Well, I don't want to call it a gut feeling necessarily, but let's say race. You feel as though your employer has done something, said some things, you've received emails, you've been called certain things, or things that just put one on alert that nobody else outside of my group, if it's African American, Black, or if it's whatever other racial group is being treated like this, then I guess that's an instance where someone would feel as though they're being discriminated against based on their race. And it doesn't necessarily have to be a situation where it's so, let's say,
in your face.
In your face, exactly.
Yeah.
It can be more subtle. There can definitely be discriminatory activity based on race or any of the protected groups like we discussed, religion or gender. And at times it's not going to be this total situation where you're being called the N-word, let's say, just blatantly, or people are passing around jokes or things that are just kind of clearly defined as discriminatory activity or activity that's inappropriate in the workplace that's actionable. It can be more subtle. My suggestion for employees, for people that find themselves in this situation, is to really take some time to sort of think about the occurrence, unless it's one of those sort of bright line occurrences where you don't need to think about it, you know it when you see it, when you feel it, when you're in there. If it's one of those things where you just kind of get the sense that decisions are being made not based on your ability, not based on your work product, but based on who you are, which Congress and the government has decided is protected. Employers do not in this country have the ability or the it's not permissible, that sort of thing, to discriminate based on your race. I'm sorry. So I was sort of describing what my expectation would be for employees, or what my advice would be for people that find themselves in that situation.
Yes.
To kind of, as much as you can, remove yourself from it. Think about what's gone on. Document all of the different occurrences. I think that's one thing that can really be...
Take it a long way, so document.
Document.
So you hear that, ladies and gentlemen, document. You can't go by how you feel or what's going on, but concrete proof. I think that helps in the litigation stage if it gets to that point, right?
Oh, for sure, Sophia. I think if you get to the litigation stage, or even before that, if you're just going to start having conversations with your supervisor, or have included your human resources or whoever sort of acts as the liaison between employment issues or human resource issues and the employees, to have this group of individuals, to the extent you have any emails, documentation, handwritten notes, or calendars that sort of talk about these different occurrences, that's very helpful, because it lets the employer see how long you've been experiencing this, what specifically is going on, and you have your own proof and documentation. It doesn't need to oftentimes be that smoking gun from an employer to you saying X, Y, and Z. That's just discriminatory, but just even if you send emails to yourself to sort of document and create your own file about work situations, occurrences, and whatever it was that just didn't feel right, I think that can definitely be helpful in sort of creating a whole picture, so you're not coming on the scene as the employee like, well, I have this one instance or whatever, and describing it and not being able to show that, no, this is well thought out. This is something I've been feeling for a while. This is something that didn't just happen overnight. I think employers are definitely more receptive to making changes then, and hopefully it doesn't even proceed to litigation, because...
And that begs the question, because the employer should have an opportunity to correct it.
That's right. And that's right. And often I've seen litigation too, especially having been on the defense side, where employers will poke holes in employees' claims because they say you haven't exhausted all of your sort of administrative remedies within the employer's environment, meaning you haven't gone through our process, which would have been, maybe including someone in human resources or a union representative, or given the employer an opportunity to correct something prior to bringing litigation. So I do think that it's to the employee's best interest to first, eradicate the problem, to get rid of the problem and say, we're going to make a better work environment. We're not going to allow our employees to work in that hostile work environment or whatever has been alleged. But it also legally can be to your betterment as an employee to have created records.
A paper trail.
A paper trail.
So let's talk about that process for a minute there, before we go to break. Essentially, there's some type of requirement. We need to at least go through our supervisory chain to make sure that they've been given an opportunity to do that. So kind of give us quickly that process of what we would need to do.
Okay, and it can vary from employer to employer, but a lot of times maybe you can look at your company handbook or reference whatever materials you've been given, whatever your supervisor has told you, or the company has told you in terms of the processes they have in place there. Talk with your managers, talk with the human resource decision makers, bring your documentation, have that discussion. If it doesn't result in some sort of change that's acceptable, that you find creates a better environment, compensates you for whatever discrimination or whatever allegations, sort of hostile environment or bad work environment you have, then of course there's always litigation, and I think at that point folks generally seek to bring in counsel even before going to the EEOC would be my advice, because those complaints really at the EEOC will start sort of the process for your federal claim.
So does EEOC handle all types of discrimination claims?
The EEOC handles the vast majority of discrimination claims, all of those that are covered under Title VII. And before you can bring your claims in, say, a district court, a federal district court, you have to have gone through the EEOC. You can't just bring an employment claim right into federal court. You have to get
that's
a right
good
to sue
information
letter.
to know, because some people think that they need to do that. So we're going to take a break here, and then we're going to come back and talk about the EEOC process and a couple of other areas.
Okay.
We'll be back in just a few moments. You are tuned into Legally Speaking, a public service of You and the Law. You and the Law is a nonprofit whose mission is to provide legal information and legal resources to empower you in your legal affairs. If you would like to have a question answered or a topic featured on Legally Speaking, feel free to contact us online at www.youandthelawtoday.org. You can also sign up there on our website for our mailing list, as well as follow us on Facebook and Twitter. Remember, with every right comes responsibilities, so know your rights and accept your responsibility. Welcome back. We're talking to attorney Yasmin Yanthis-Bailey about employment discrimination. Prior to the break, Yasmin, we were talking about different types of discrimination out there, and now we want to talk about the process that one would go through. You mentioned that we've documented, we've talked to our supervisors. At this point, we haven't gotten the result that we think that we need. Now you're saying the EEOC, the Equal Employment Opportunity Commission. What is that process like?
Well, and that process is definitely an administrative process that's been put in place, and it's part of the requirement in Title VII that you go to the EEOC and file a complaint. And my recommendation is that even at that point of going to the EEOC, that employees seek counsel before filing your complaint, because this is when you're really going to state and let your employer know what your concerns are. And you want to frame it in a way that's going to get a response. You want to make sure that you're including everything, because employers will use that against you if you haven't included all of that information in this initial complaint. Now, of course, a lot of people do go to the EEOC without a lawyer, without the advice of counsel, and you can still be successful and move forward. But I do think that it's helpful to have counsel with you when you go to do that complaint and draft everything, because then you're making sure you include it all. And of course, I should mention that the EEOC, when you bring those complaints to the EEOC or a private sector employee, that's the route that you would take to bring a Title VII claim. If you're a federal employee or work within a different government agency, there are different mechanisms that you can use to address any sort of employment discrimination complaint that you have, and the procedural requirements are different. But
so we have if you're in the private sector, I need to find my nearest Equal Employment Opportunity office.
That's right.
And if I'm in the federal sector, there is some internal things that we need to do?
Right, there are internal mechanisms that you would use. You still do go in front of the EEOC, but it's a different process.
Route to get there.
It's a different route to get there. You usually have to talk with your agency, Civil Rights Center, or other employment board, and start a whole different process. But of course, that's for folks that work with the federal government. Different county or state governments can have their own processes too for sort of public sector employees. But for the vast majority of folks who work with the private sector, you're going to find you'll be at the EEOC.
Okay, so what happens when I go into the EEOC, I file my complaint, what happens next?
Well, what happens next can take a lot of time. Oftentimes the EEOC, and especially in recent years with the recession and people sort of, bringing more complaints because you're feeling something, you're feeling that you're being discriminated against, and you don't want to lose your job because you're not going to get another one tomorrow. So I think the EEOC has mentioned that their employment discrimination claims have risen in the last couple of years because, people are concerned about their jobs, right, and concerned about what they're feeling on the job, and want to make sure that any sort of discrimination that they're confronted with is formally presented, and you're not just terminated based on sort of discriminatory activity. And
so you should be prepared for not having a quick fix, but
that's
know that
right.
it will get addressed.
Exactly. And sometimes the EEOC will get certain cases and give a right to sue letter within a short period of time, and that right to sue letter, once you receive it, means that you can bring your complaint in federal court. Other times the EEOC
So what's the process to get to the right to sue letter? I filed my complaint. Is there some type of hearing or investigator I talk to, or what is that process?
Well, that's kind of a paper process where you file your complaint and you list everything, you sign your name to it, and it's fairly exhaustive, asking the circumstances, asking what are the basis for your complaints. You check different boxes. That's why I say sometimes it can be helpful to have that attorney. Make sure you're checking all the boxes for the different discrimination that you're alleging. And so you go through that process, and next the EEOC, and I'm not sure of all of their internal mechanisms, but my understanding is they review these. Some they recommend for litigation. They bring their own litigation. The EEOC has
they have
their
the power
own.
to do so as well.
They have the power to do so. They won't necessarily give a right to sue letter, but will talk with the complainant about bringing the case themselves. Now that's a very small percentage of cases, just given the resources the EEOC.
But it's a possibility.
But it's a possibility. Settlement also happens. I've had a number of settlement discussions or mediations with employees and employers at the EEOC level, which is also a good opportunity
So
to.
you can get it resolved sometimes without having litigation.
Right, that's right. And that's also a good thing, because you're not going to wait for years for a result. It may be much more quick. And then I'd say the vast majority of cases, the EEOC generally refers to a right to sue letter. I've not seen too many instances where they won't issue a right to sue letter, but that can happen too. Let's say you go to the EEOC and try to file a complaint based on sexual orientation. Well, that's not covered under Title VII, so they're not going to issue a right to sue letter.
Okay, so wonderful, but we're running out of time. I want to cover a couple of areas before we leave there.
Oh, yeah.
Okay, let's talk about military leave. We've been in a time of war of sorts in this country for a while. So if I'm a military person and I'm working, what rights do I need to be aware of as far as my employment is concerned?
Right, and the military, again, this is an area where Congress, the government has said, we value the service. It just makes sense. We value the service of the people in our armed forces so much that your job is protected when you are called to active duty. And there are a number of procedural requirements and steps that employers must adhere to when their employees are called for service. You can't be called for service and then you lose your job because you have to go serve your country. No.
So what if I come back and they try to give me a different job than what I had before I left, with different pay and different things of that nature?
Right, and that too is covered in the USERRA statute. There's a whole act that sort of protects this activity, and those situations are addressed. And no, you can't come back to a completely different job. Now, the employer can do certain things to, give comparable work, that sort of thing. But if you come back, you left, you were making $45,000. You come back and they're trying to give you a $20,000 job. No, that's not
so
right.
It has to be comparable in duties as well as comparable in wage.
Right, there are, and I'm not fully versed with all of the requirements, but I know that a lot of places where you can go to sort of reach out and get additional information about this would be the Department of Labor, the United States Department of Labor, the website.
And what is that website?
That website is www.dol.gov, and there's a whole section on USERRA, which is the Uniformed Services Act, and it directs folks, veterans, to you can contact DOL, you can contact vets, but know that your employment is protected. To me, it makes a lot of sense. If you're serving your country, you come back, you're entitled to a job. That's the least sort of
and there's a protection in the
expectation
law for
that people can do, and there's protection for that. That's right.
Now, we're hearing a lot about FMLA, or the Family Medical Leave Act. What can an employee expect under that particular act as far as their jobs are concerned?
Right, and that's, of course, another instance where people are increasingly needing to use FMLA, the Family Medical Leave Act, to address concerns with their immediate family, extended family, to take care of themselves. And it's actually one of the most misunderstood laws out there, although it's one of the laws that is most necessary and needed by
help us
both.
understand
I know,
it.
right?
Help us understand it.
Exactly. No, there are a lot of complex issues that can, kind of arise with FMLA because situations can be so specific. But that too is an act where if you qualify, you are allotted a certain amount of time, unpaid leave, where your employer must keep your position open, during that time where you're taking this leave. And you're protected. You're protected to approach your employer to ask for this time. You can't just leave and then try to call and say, I'm on FMLA. No, that's not going to work. We have to get clearance in the beginning to go and follow your employer's administrative processes for getting that leave. But that's, again, another sort of leave where as long as you're in sort of an interactive process, communication with the employer, being told what you're expected to do, letting the employer know what you're going to do, providing medical documentation if necessary, it's something employees are entitled to.
So if I have went through all those steps and I otherwise qualify for the statute, can my employer say, I'm not approving the FMLA, you can't take it?
There are certain instances where the employer can have a position to, deny leave based on, a certain number of things. But generally, if you've provided what is called for under the Act, you've followed your employer's processes, you're entitled to take the leave, meaning you've worked there for at least 12 months and have put in at least the number of hours that were required to make you eligible. No, employers just can't blanketly say, if you followed the law, they're subject to FMLA, we're not going to agree to your leave because we don't like you or whatever it is. No, that's not an option.
Okay. Well, I want to move, before we leave today, I want to move into an area and I want y'all to all tune in right now. Facebook and tweeting. And we're seeing a whole lot of, I hate my job, I hate my employer, all these people are crazy on Facebook. So is there anything out there that the employee should be aware of when they're deciding to make that Facebook post after they've gotten into it with their coworker or with their employer on Facebook?
Well, my recommendation, Sophia, would be don't use that as a venting tool, okay? Because while the circuits and the courts are sort of divided on how it's coming out with some of the employment actions that have been taken based on, use of social media, you don't want to be in a position where you're terminated and then fighting for your job for, a couple years or whatever because your employer has taken an action. And there are definitely employers, if you sort of disparage the employer on the internet or you talk about certain individuals or whatever, that's not protected. You're not entitled to just be able to, necessarily make those statements or put up comments
I have First Amendment free speech. What you mean?
Yeah, no, I know. And that's why I think there are some courts that are coming out a bit differently in terms of the decision. But my advice generally would be to, use other sources, talk to your friends and family or whatever it would be.
Well, let me ask you this to kind of bring it home. Is there cases out there, or are there cases out there where someone has been fired over a Facebook post and have been upheld?
Oh yes, and that is definitely occurring more and more. Employers are, taking strong positions with regard to the decisions that they make for employees or former employees who disparage the company, read these posts, or even in hiring decisions, honestly. So if you're trying to seek a job too from these employers, or, we just always want to be careful. I think it's prudent to take steps to, eliminate any possibility that you'll be terminated or not hired by an employer based on your social media venting or blogging.
Exactly. And I think that's an excellent point because I see a body of law that's being developed around that is actually being upheld.
That's right.
Well, we have come to the end of this show, if you can believe that.
Wow, that was a quick time.
Yeah, it was, but you gave some great information. We thank you so much for coming to see us. You have to come back and see us again.
Oh, well, thank you for having me. I appreciate it.
All right, folks, you heard it here. There are a lot of avenues out there on employment discrimination, whistleblower type things, and even we talked about a little bit about Facebook. So we want you to be careful of the action that you're taking out there because you could do something that puts your job in jeopardy. Remember that Legally Speaking is shown a new show every Sunday at 6 on our website, www.youandthelawtoday.org. And remember, until next time, with every right comes responsibilities. So know your rights, accept your responsibilities. We'll see you next week.